Hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court. And as always, I hope you're just having the most wonderful of days and the happiest of New Year's. I hope you and yours had a great one, and wherever you are, you had a great time with your family, maybe got some great Christmas presents, maybe had some good food. Over here in Uncivil Law land, we made a nice beef Wellington on Christmas Day, which many of you were in to watch with me, and a very special edition of Cooking with Kurt, which we sometimes do. But for today's Christmas gifts, we come in the form of a Grinch Scrooge, the form of Johns Hopkins, who despite being given a gift they didn't really deserve in the first place, are complaining. They are the Veruca Salt of this tale. Nothing is ever good enough for Veruca or Johns Hopkins. No matter what her father / Judge Carroll does to please her / Johns Hopkins, they always pout and complain and say, I want it now. It's never good enough. Nothing's ever good enough. But if fate is yet kind, in our increasing analogy, Johns Hopkins, much like Veruca Salt before her, will stand on a measurer designed to determine whether eggs are good or bad and fall into a vat, possibly to be followed by a broiler, which may or may not be on. Willy Wonka was a bit ambiguous about that, but that hopeful outcome is yet to occur. What we have now is some more demands from the petulant child that is Johns Hopkins in the form of their motion for reconsideration of the scope of the interview. Somehow, some way, getting what they wanted, despite my every expectation and legal analysis, where I literally laughed in their face because their motion was so incredibly dumb and so incredibly against policy. But somehow the judge, being a weak Judge Carroll, although he's certainly not only judge to blame, because apparently all the judges in Johns Hopkins are super duper weak because none of them ever want to break out the whacking stick. So the judge, having given them a bit of a taste of what they want for reasons that passed my every legal understanding and analysis, and, I don't get it, but, unsurprisingly, completely true to character, Johns Hopkins is over here like, can I have some more, please, sir? Can I have some more, please, sir? It's not good enough for us, the lowly Johns Hopkins. Oh, no. They're going to come, Juror 1 is going to come into the courtroom and they're going to tell you exactly what you've already heard. Which, yeah. So, of course, that's not good enough because they're going to tell you the same lie they've been telling you all this time. So the whole thing is pointless. Which sounds like a pretty good reason not to grant it in the first place, if I'm quite honest, yeah. But that's sort of where we are. I do have a favor to ask, however, before we get started proper, okay? This is a personal request, and I really could use your help, okay? As Recovery Addict was talking about, I was doing a stream on New Year's Day regarding Steamboat Willie, a cartoon created by Disney 95 years ago, which, pursuant to the fact it was 95 years ago, just fell out of copyright as of New Year's Day. However, YouTube took down my stream, deleted my stream for repeated instances of portraying copyrighted content on the stream and gave me a community guidelines warning for repeated copyright violations of using Steamboat Willie, which is not in copyright. It's in the public domain. It's copyright expired. So they took down my stream and they gave me a community guideline strike, which is a pretty big deal for a creator, because of me repeatedly using copyrighted material that's not in copyright because it's in the public domain. So I have a favor to ask. If the people who are here would be so kind as to please go to the pinned link that's in the comment and retweet it, it would make a huge difference. Yes, I appealed it. But, nothing works better. The creators have globally found out that nothing works better than Twitter shame. Twitter shame is best shame. So I would really appreciate it if you would please help me in this endeavor, because it would really help. So about 20 of you have so far retweeted, and if we could get those numbers up to several hundred, I'd really appreciate it. That'd be great. So, anyways, please. The pinned comment is new. It's new as of today. So if you retweeted in the past, please retweet again. We need new retweets. This tweet today is as of this morning. I'm continuing to shame them. So even if you tweeted yesterday, do it again today. I need your help. Thank you. Turning back to the subject matter at hand, we have the motion for reconsideration of the scope of the juror interview of juror number 1, because we want all the things. We want all the things, and we want them all forever, because we don't know how to say yes. So Johns Hopkins, by and through their counsel, pursuant to law, lol, files a motion for reconsideration of the court's order granting a limited interview. I think the court should reconsider the whole thing as being stupid. I mean, the judge can just do it sua sponte, right? The judge can just do their own motions on their own initiative. But they did just literally ask you to reconsider. So now would be a good time to reconsider. Maybe this whole thing is dumb. That'd be great. The scope of the interview must be expanded because defendant's supplemental evidence of juror misconduct, including juror number 1's material false statements on his jury form, what the F, is timely and requires inquiry. The interview's current scope would inadequately investigate the potential misconduct. Yeah, we want all the things, and we want them all forever. And defendant has learned of additional improper communications between jurors 1's plaintiff's counsel and the jurors that required additional inquiry. Not for nothing, but once the jury is done, the jury is allowed to talk to anyone. I seem to vaguely recall that, the judge saying almost exactly that, in almost exactly those words, right? Anyone can do anything. And the juror's wife is certainly not, of the attorneys. She's not a agent for the attorneys, so she can go up to the jurors and be like, "Hey, what's up, jurors?" They're like, "Not much. What's up with yo?" She's like, and she can basically have any conversation she wants with them, because she's a free person. We think. We're not sure, because Johns Hopkins makes us think sometimes that maybe juror 1's wife isn't a free person, which is a new and interesting concept in the now year 2024. But okay. Although the prospect of starting over with a new trial is understandably frustrating, if not for the least of reasons that you, Johns Hopkins, have done everything in your power to make it frustrating at every possible turn, this court cannot and must not sacrifice the integrity of the jury process in the name of expediency. Yeah, that's true. But they can't sacrifice the integrity of the jury process just for the hell of it either. Right? They can't sacrifice the integrity of the jury process in the name of expediency. True, but they also can't sacrifice it just because wishes and dreams and hopes and, I made a kiss under the mistletoe at 12 o'clock sharp midnight on New Year's Day, where all my wishes come true. Other people were proposing to their love to become fiancés. I was proposing that I get all my wishes in this analogy. All right, great. Juror 1 was first to arrive at the courthouse for jury selection. He's literally juror number 1. So he was probably the first. That's deep clue. He completed the Sarasota prospective juror questionnaire, falsely answering that neither he nor a member of his immediate family ever been the victim of a crime. During voir dire, juror 1 clarified another answer by saying he had never been charged with a crime, but his stepson had, which you could have, followed up on. You could have followed up on. Your stepson was charged with a crime. What was the nature of that crime? But you didn't follow up on it. He did not correct his earlier misstatement to explain he and his wife had been the victims of one of the stepson's crime. Well, not for nothing, by the way, of course, for it to be a lie on the voir dire, it has to be knowingly a lie, right? So you have to know that you're lying. That's the difference between a mistake or a misstatement or a falsehood and a lie. So for something to be a lie, you have to know that you're telling a lie. And if you just make a mistake, that's not a lie because there's no intent to tell the lie, right? You just made a mistake. So if you ask me like something like, I don't know, do you know so-and-so? And I say no. And it's like, oh, wasn't it true that they were a member of, your, I don't know, college newspaper when you're in college? And I'm like, oh, yeah, you're right. I know them. And you're like, liar. I'm like, dude, I just forgot. It was, 20 years ago. I just kind of forgot, so forgetting is a thing. And also, much like me, this thing with Juror 1 was also 20 years ago. And also, so he doesn't remember it. So the whole thing is a little bit odd. And yeah, he didn't think about it. And also it has to be material for it to matter in sort of U.S. government terms. So it has to matter, which I'm not sure it does, and it has to be a lie. I'm not sure that it is that either. Okay, great. We're up to 91 retweets on the tweet as of this morning. This morning's retweet, we're up to 92. Let's see if we can get that number up. There are 1,100 of you in chat. I'm not beyond begging for all 1,100 of you to please retweet this thing. I need your help, please. Throughout his trial, Juror 1 asked questions reflecting clear pro-plaintiff and anti-defendant bias, lol, and demonstrating he had already formed conclusions about liability, also lol. He's asking questions. He has some thoughts. He has some maybe tentative ideas. He might be leaning a particular direction, but that isn't quite the same thing as a conclusion, right? Right? Just because you're leaning a direction doesn't mean that you're not open-minded. And to a certain extent, the lawyers very much would like to know if the jury or the judge is leaning a particular direction, right? Because it, especially through the questions they ask, it might give you some insight as to areas which you're weak, and you might need to, rebut. You might need to bring other. Like if the judge or jury is saying, you know what, I'm not so convinced about this aspect of the thing, that's a pretty good clue to the lawyer being like, oh, you know what I should probably do? You know what I should probably do? I should probably try to emphasize that thing, because there's at least one juror who's like, you know what, I don't think I'm really convinced on this. Could you give me a little bit more? Could you give me some more? Right? That's the kind of thing you like. So, a good lawyer wants to know if they're behind, so they want to know what they can try to fix. And ultimately, they may not be able to fix it, right? At the end of the day, put a dress on it. A pig is still a pig. So you can only do so much. But the lawyer wants to know where they have to try to buttress the thing, even if they can't figure out how to do it, because the thing is beyond buttressing. But they want to be able to know. So, yeah, Johns Hopkins should have been thrilled about these questions, because it would have provided a wonderful opportunity for them to learn in the ways in which they're behind and might need to readjust their case. But now they're really sad because they're like, oh, the questions were saying that we're not winning, and we didn't win. Lol. Defendant moved to disqualify juror number 1, which was a stupid motion, and I laughed pretty hard. When the motion was filed, defendant was unaware of juror 1's wife, who is not juror 1. Or are they? Are juror 1 and the wife the same thing? I mean, I remember the whole part of the Bible about a man shall leave his father and a mother and shall become one flesh with his wife. But I didn't know that was super duper literal, like they were literally the same person all the time. I didn't know that husbands and wives like merged like some sort of creature where they just absorb into one body permanently, and they're now like this one in the whole. I don't know. I seem to remember like wives walking around without their husbands, but maybe it's a whole doppelganger thing, or body. Maybe it's a body shifting thing. I don't know. Maybe it's like the T-1000. Maybe they can take different forms at different times. I don't know. I don't know how any of that works. Anyways, at a November 6th hearing on the motion, plaintiff's counsel initially agreed to swap juror 1 with an alternate in what I thought was a very bizarre move by the plaintiff's attorney, Maya's lawyers, and I laughed at it pretty hard because I thought it was dumb. Before being asked to consult with, his client, that might be a good idea. I'm not sure I don't think he has to abide by his client's wish on this factor. Incidentally, I think I'm pretty positive that it's ultimately the lawyer's call. So his client, but asking the client what they want as part of making the ultimate decision might be a good idea. So after speaking with his client, he then returned to the bench and told the court that the client feels more comfortable with Juror 1. Okay. Had defendant known of Juror 1's wife earlier presence in the courtroom and friendship with plaintiff's advocate, the notorious Jules, although she doesn't get a mention by name here. She doesn't get a mention by name. So that's a little sad. Unless she literally means that unless they literally mean that Juror 1's wife is also now plaintiff's advocate. So I'm not sure who they're talking about at this point. Has Juror 1 now become the notorious? Has the title shifted? I'm not even sure who we're talking about right now. Counsel would have moved to ask the client if he knew of Juror 1's wife presence or any contact with her, questions that still are not answered. Yeah, I don't know why that's necessarily a problem, right? I seem to remember that, Juror 1 took an oath, and I don't remember that Juror 1's wife took an oath to not look at the media or not watch documentaries or not talk to Jack or anyone else. They are separate people, right? Right? I mean, Juror 1's wife is a separate person from her husband, right? So, this all gets down to whether Juror 1 was corrupted in some sense. I don't really know how Juror 1's wife feels into this thing, but, yeah, okay. The court denied the motion because it was incredibly stupid. The judge finally demonstrating something of proto balls, lol. Ruling that Juror 1's question were not biased and had not come up with any final or fixed opinion in the case. We're now at 114 retweets. Your continuing retweets help. They really do make a difference. You'd be surprised how much of a difference they make. They really do matter. On these kind of things, it really makes a huge difference. YouTube does tend to respond to Twitter. I know it sounds stupid, but it's the only way to get their attention sometime. So please retweet the pinned comment. Please. It's a new tweet as of this morning. If you retweeted prior to today, you need to retweet again. We love you. Please. The Juror 1 motion detailed extensive information learned about Juror 1 and his wife, including that during the trial, Juror 1's wife sought out and befriended a woman named Jules, an outspoken plaintiff's advocate who, according to her social media posts, communicated regularly with the Kowalskis and advocated for them in person online. And therefore what? And therefore, hey, we're up to 366 retweets. Wow, that really popped off. It's crazy. So I guess the counter wasn't real time because it just became 366. Oh, okay. Thanks. Appreciate it. It's like I look over one moment, it's 111. I look the next moment, it's 368. Anyways. All right. Juror 1's wife shared her personal contact information with the Jules. The Jules. Jules. I don't know. She's Jules. Who will save your soul? La da da la da. Who will save your soul? All right. Sat next to her and chatted with her in courtroom during the trial when her husband sat as an impound juror. I'm pretty sure it's an open courtroom that anyone can go to at any time. The extraordinary public attention in this case, and by the way, it's not that extraordinary, not for nothing, continues to generate highly relevant evidence. Yeah, I'm going to press X to doubt on both those things. First of all, not for nothing, the evidentiary phase is over. I remember it happening. I remember when they said to the jury, hey, jury, why don't you go into deliberation room and, let us know what you think. That was a pretty good clue that the evidentiary phase was over. Johns Hopkins doesn't seem to understand how this works. Let me help you out. There's a discovery phase, and then that phase comes to a close, and then there's a trial phase, and then that thing comes to a close. Yeah, the evidentiary phase is over. Second of all, that it's extraordinary public attention, man. I don't know what to tell you. Does anyone remember the Johnny Depp trial? This wasn't the Johnny Depp trial. I mean, it was notable, but it wasn't the Johnny Depp trial. Or probably even the Rittenhouse trial, or any of the Donald Trump trials, or many, many other trials. So I'm not sure, or, Chauvin with George Floyd. That seemed to get a lot of public attention. That might even be more than Johnny Depp. The protests were pretty real. Even Johnny Depp, made it look like a cakewalk. Pretty sure Chauvin/Floyd got more attention in Minneapolis than this. So I'm not sure how extraordinary it is, but, okay. Beside broad media coverage of the case, his internet superfans across the globe who spend hours each day not only watching trial online and discussing it in chat rooms, but also publicly searching the docket and poring over documents. Again, apparently, all you guys in chat are very, very bad and have sinned. It's okay, though. It's okay, because it's a brand new year. It's a brand new year, and I know you're here in this chat right now with me, looking at this stuff, but now is a good opportunity to take the benefit of the new year, the New Year's amnesty, and take the opportunity to be like, you know what, as a member of the public, I shouldn't be interested in the public trials that are happening in the public in a public way. As a member of the public, I really should not care about things that are on a public docket in a public courtroom. I really shouldn't care about the public filings that are filed before the public. I shouldn't want to discuss these things with fellow members of the public. I'm reformed. It's your opportunity to reform, man. It's your opportunity to reform and not do any of those nasty, nasty vices, those vices that so many of you have done by actually, caring about court proceedings, looking up dockets and reading them, and occasionally even listening to actual lawyers commenting on them. Whoa, the depths of your privations are truly, truly deep. It is time. It's not too late, man. It's not too late, man. It's time to go to that mass. Time to go to that mass and pledge to God a whole new life, man. Not worrying about the public things with the public filings, or not worrying about any of this stuff. It's not for you. It's not for you. It's not for the public. Good times. All right. Many, like Jules, are pro-plaintiff. Many are not pro-plaintiff. There's a whole anti-Maya subreddit out there who Johns Hopkins seems to be getting their ideas from. It's amazing. Members of the public watching the public trial in a public way sometimes have differing opinions. Maybe not everyone always sees it the same way all the time. Maybe people might want to express those opinions and even potentially, here's an idea, potentially even learn from each other. I know, it's shocking because the internet mostly these days is just about yelling about, the other side and yelling about them. But, you could actually listen to the other side on the premise that they might have something to teach you, at least why they're confused or why they think they're confused, and actually engage in dialogue, like the polis that you are. Right? That's the whole thing. Where does the word politics come from? It comes from polis. What does polis mean? People. Population. Yeah. Anyways, the people have thoughts. Many, like Jules, are pro-plaintiff, while others believe that the hospital has been treated unfairly. They sure do. And to some degree, I think they even have points that are valid. I don't think they have points that are necessarily valid in the sense that they will undo the verdict, because, that's a whole nother can of worms. Just because I disagree with a court doesn't mean that I can magically fix it. And I've talked about that before on my channel, where there's been decisions where I've had to simultaneously put myself in like both the theoretical position of trial judge and the theoretical position of court of appeals. And we've had that position, right? Because a judge does something, I'm like, okay, as theoretical trial judge, I would have gone the other way. As theoretical court of appeals judge, there's nothing I can do about it. Because discretion, right? So we've talked about that, right? So do the anti-Maya people have some point? I mean, I think they do have some points, especially when it comes to the amounts of the awards. I think it's reasonable for a person to conclude that they're excessive, even substantially excessive, although I think Johns Hopkins' ask is kind of insane. But, you know, you could definitely be critical. And you could also think that Johns Hopkins, I suppose, is generally a good hospital who does generally good things and should not be blighted by this one error. But, yeah, you know, that's another thing for another time. The court, understandably wanting to affirm that parties' counsel are not deputizing the internet community to do indirectly which an attorney is expressly prohibited to do directly, had pointed to the relevant rule of professional conduct which prohibits attorneys from initiating, and the key word here is initiating direct or indirect post-trial communications. In other words, they have to cause it. They have to cause it to happen. To be clear, no one on the defense team has initiated contact with the helpful members of the public, initiate direct or indirect contact with juror, or ask anyone to take action the attorneys could not ethically or legally take themselves. And then there's this footnote about how they're not going to, you know, provide affidavits because of the holidays, which, you know, whatever. But as to the fundamental premise that defense team has not asked members of the public to act on their behalf, I'm not so sure about that one, Johns Hopkins. I have to respectfully say I'm not so sure about Johns Hopkins and their lawyers not asking the public, the bus stop people, incidentally, the very bus stop people that they insulted, but never mind. They are not beyond asking the bus stop people that they themselves insulted to help them and have expressed thoughts that might be thought of as being viewed, capable of being viewed as, we like Reddit. Reddit is good. Please, people on Reddit, please helping us because we're not very good lawyers and we need the help of the bus stop people. How must the lawyers feel at Johns Hopkins? How must the lawyers feel that they've had to crawl on hand and knees to the bus stop people to ask them for legal tips? That's rough, man. I mean, again, I think it's worth noting here. One of the reasons it's particularly rough is just because of how well financed Johns Hopkins is, right? So I've certainly seen lawyers do this and not be as critical about it, right? But mostly in those situations where I'm less critical, it's because the lawyer is a guy, right? Or is with a small firm, right? So you run into these situations where it's like, hey, you know, I'm just one guy. I'm a one-man show or close to it. And so, you know, members of the public, if you can spot things, maybe you can help check my thinking. So I've seen lawyers definitely go to social media for help, and I don't think that's necessarily inherently bad, but it is a little bit ridiculous, one, to deny that's what you're doing, and two, in Johns Hopkins' case in particular, it's a little ridiculous because Johns Hopkins lawyers have all the money. They have all the lawyers and all the paralegals and all the consultants and all the everything. And still they need to go to members of the public. So even your massively well-financed legal team from your white shoe law firm with all your paralegals and all your assistants and all your secretaries, all the king's horses and all the king's men can't put Johns Hopkins back together again. So maybe if we get members of the public to help, maybe that would work. Lol. All right. So I'm not so sure about the we didn't contact the jurors part, but okay. Members of the defense team have, however, received unsolicited communications from members of the public, in addition to unsolicited threats and insults. Members of the defense team have received unsolicited and highly relevant information. No, you haven't. I've seen your information. It's not highly relevant. It's not relevant. It's not even really information. It's none of those things. It's not highly, it's not relevant, it's not really information. It's some rumor, innuendo, and some bullshit. Discovered by members of the public. Don't you mean the bus stop people? Who studied the trial. The unusual dynamic of this case does not make the information any less relevant. It also doesn't make it any more relevant than if it had been discovered by the attorneys themselves. Nor is the information untimely or unwaived if produced as soon as practical in advance of the ruling. If relevant and substantial must be considered. Yeah, that's not how that works. That's not how that works. Yeah, that's a law and order thing, not a real thing. You can't just magically run into court with, I have the document. I have the smoking gun in my hand. You know, especially after the jury has already returned a verdict. Particularly after the jury's already returned a verdict, right? We found the smoking gun. We need to introduce this evidence. Yeah, that moment's over now. That's over. You know? So not really so much now. Ask any convicted person, incidentally, about this, and they'll tell you the sad stories. You know, the convicted people whose witnesses retract their statements, and it's been known to happen, right? There's been people who have been convicted, and then later, basically every witness against them, every witness who testified against them gives a sworn statement that says, yeah, I was lying, I made it all up, he didn't do it. Does that magically undo the conviction? No. Does it undo the conviction at all? No. So, yeah, even literally every single witness retracting their testimony. Yeah, that moment's over now. So I hope you enjoy jail. So, yeah. So they want to bring in the magical evidence after the jury's already sat, and that's not how that works. The extraordinary public interest in this case has prompted 3 supplements. 5 days after Juror 1's motion was filed, defendant supplemented the motion with more evidence of impropriety. Defendant learned that in 2002, Juror 1 was accused by a former spouse of domestic violence. In 2002. During a divorce proceeding. Well, that's certainly the first time I've ever heard of, you know, someone being accused of violence in a divorce proceeding. Boy, oh boy, I've never heard that before. I've also certainly never heard of someone claiming domestic violence falsely in a divorce proceeding, or even abuse against children falsely against a divorce proceeding. Never heard of that before. What a novel concept. Defendant's first supplement also pointed to Juror 1's post-conduct postings, and post-verdict would be the critical part there, because he can do whatever the hell he wants, including a post where he intimates that defendant's counsel are immoral and evil. Well, at the conclusion of the case, he can have any opinion he wants. So he can think that they're immoral and evil. I think their attorneys are immoral. I think they're bad lawyers. I think that they're a discredit to the profession and should be publicly reprimanded. I think Johns Hopkins also doesn't get it. And they are evil in the sense of apathy, right? I think, yeah, it's more evil in the sense of apathy. It's like, I'm not sure they're actively trying to cause harm, but they just don't care. So, yeah, I think those are views that might, you know, be reasonable to have about this at this time. Juror 1 does have an attorney, by the way. Thank you for asking. It's not me, but I know he has an attorney, which is great. So I'm happy about that. I believe he's going to file a notice of appearance at some point today. So we'll see. All right. Something to look forward to as you're monitoring that court docket. I believe that their attorney may file a notice of appearance today. I wonder on what basis I might think that. You know, I'll have to leave that to speculation. Still more evidence of Juror 1's pre-verdict bias came to defense attention before December 15th hearing. Leading defendant filed a second supplement to Juror number 1's motion on December the 7th. Defendant was alerted to a note written by Juror number 1. We know this already. We talked about this, Johns Hopkins. We know this. We know this. He was alerted to a note by Juror 1 in which he inexplicably draws the capital letter S in Sally Smith's name. Name markedly different than every other S, which was a lowercase s. And they present the exact same motion, but the exact same thing, but this time with new and exciting highlights. Just because in case we didn't get the point the first time, right? We've already seen this note. Remember, by the way, this is the juror's note to the judge, not their personal notes. So these are a matter of public record. So, no problem there. But yeah, the Sally Smith S's are written a little differently than every other S. But every other S is lowercase. Yeah. So they're the only capital S's that are in this entire document. So written a little bit differently. And we think maybe the S's are a little sharp. They're a little too sharp for our taste. Yeah. Hold on. All right. Let me put up the noise gate just a little bit more. Change it to 30 and 31. Great. All right. Given the similarity of the S's to the Nazi SS lightning bolts, really, we call this Godwin's law, right? For those of you who have been around on the internet for a hot minute, Godwin's law. As any conversation on the internet goes on, the probability of someone invoking Hitler or the Nazis increases to 1. I knew that was a law of the internet. I didn't know it was law of the court filings. But we've literally gone to the part of the court filings where we're literally invoking the SS Nazis. That's super duper. Incidentally, by the way, the corollary to Godwin's law is that you need to that anyone, the first person to cite it, the first person to do it, loses. A few days before the December 15th hearing, defendant learned of yet another material misstatement that Juror 1 made on his jury form. Defendant provided the information to the court at the hearing and subsequently filed the third supplement for Juror 1's motion. On the juror questionnaire, Juror 1 said that neither he nor any member of his immediate family have ever been the victim of a crime. In January 2016, however, Juror number 1 and his wife, apparently before they were married, called the Charlotte County Police and reported that Juror number 1's wife's son had repeatedly threatened to kill them. So, wait a second. This is before they're married. So what was the question again, exactly? Hold on. Yeah, so this is hold on. He said that, he said, okay, yeah. So this is good, right? So it's not even a lie. It's not even a lie. Look at how the question is phrased. Like, juror number 1 said that neither he nor any member of his immediate family had ever been a victim of a crime. But at the time in question, that statement was true. Because at the time in question, Juror 1's wife's son had repeatedly threatened to kill him. But at the relevant time, Juror 1's wife's son was not his stepson, because they weren't married yet. So when he said that neither he nor any member of his immediate family had ever been a victim of a crime, he wasn't even a member of his immediate family at the time. So it's not even a lie. All right. Juror 1 had applied for and received an injunction for protection against repeat violence in the 12th Judicial Circuit. Attached to Juror number 1's petition for the injunction was an 11-page document detailing Juror 1's stepson's criminal history, his threats against Juror 1 and his wife, and explaining why Juror number 1 believed his wife's son was planning to carry out the threats. In July of 2016, hey, we're up to 1,400. We're up to 1,400 retweets. So you guys are kicking ass. So please continue retweeting. We do appreciate everyone who helps. Retweets beget retweets, man. Retweets beget retweets. We do appreciate everyone who helps. Thank you. Retweet the pinned comment. Because the events all took place in Charlotte County, defense counsel earlier searches of local databases did not reveal the improperly withheld information. On December the 20th of 2023, this court issued an order granting a limited interview of Juror number 1. The court ruled that defense allegations contained in the second and third supplements of Juror number 1's motion were waived because, although the motion was filed within 15 days of the verdict, the supplements were not. The court further ruled that Juror 1 the interview would be limited to 4 topics. Whether Juror 1 received or shared information about the subject matter of trial through outside sources, including a spouse. Whether Juror 1 conducted an investigation about the subject matter of the trial. Juror number 1's knowledge of Deborah Salisbury, if any. And whether Juror number 1 had an undisclosed opinion about DCF or any other entity, which he didn't, incidentally. Because DCF was involved in proceedings that he were not involved with because it involved his wife at a time when they weren't married. The court also expressed concern that counsel was deputizing an internet community to do indirectly what an attorney is expressly prohibited from doing directly, and quoting the relevant Florida law, which prohibits attorneys from indirectly interacting. As will be sworn in forthcoming affidavits, which we're not going to present now because we're too lazy, because we're on holiday, even though we had no problem incidentally filing this motion despite the holiday, but we couldn't do our affidavits because of the holiday for some reason. None of the defendant's counsel have initiated communication with jurors directly or indirectly, and have not encouraged or solicited members of the public to do so. Yeah, I'm going to press X to doubt on that one. I'm going to press X to doubt on your sworn affidavits that are forthcoming. I think you've said things in the past that are like, yay, Reddit, we like Reddit. Please give us more things, Reddit. We really appreciate it. Plaintiffs apparently cannot make the same representation. Give me a break. As described in argument section C, defendant has learned that post-trial, a note was delivered from Juror 1's wife to the jurors and alternate jurors. So what? Providing Nick Whitney's cell phone number and delivering a message from Nick Whitney to the juror. The note also contained Juror 1's wife contact information, Jack Kowalski's contact information, a list of YouTube commentaries that followed the trial, and final admonition from Nick Whitney advising as the case is on appeal, be careful what they say on the media. And an image of the redacted letters below. Well, I'm glad you finally learned how to redact things. That's nice. Thanks for not, blasting their cell number and email all over the internet. That's nice, I guess. So Juror number 1, Jack Kowalski. We had his his cell phone number, maybe his address, Nick Whitney, who said, please express our overall gratitude for having justice for Maya, Beata, Jack, and Kyle. All the jurors fulfilled their solemn duty and were forever in their debt, which is about as generic a comment as a lawyer can possibly say. Do you have any thoughts for the jury? Yes. Thank you for your assistance. You fulfilled your duty. We are thankful. That's fine. The judge said that. The judge said that in almost exactly those words as he was dismissing the jury. The lawyer's like, yep, I echo those comments. That sounds good to me. That is not what the rule had in mind. That is not what the rule had in mind when they're like, don't indirectly contact jurors. Yeah, if you give a press conference, you're like, I want to give a special message to every single member of the jury. We really thank you for your service. We appreciate your diligence, and your justice has been served. This is not what the rule had in mind. Yeah. Yolanda, wife of juror number 1, would be glad to text the links or help to anyone access links. And then here are apparently all the YouTubers you should follow, one of whom is particularly good. Here are some great links you can follow for the trial and lawyer Lee Craps. They're all on YouTube. You can search for their name. Recovery Addict has an entire trial go-to his playlist. Recovery Addict kicks ass. Law and Lumber, incidentally, by the way, it's with an ampersand, not with the word and. But, I'm sure Rob forgives you. Megan Fox, who is not a member of LawTube, and at least in my humble opinion, you should not watch. Lol. Lawyer you know, Peter, great guy. Uncivil Law, who is absolutely the best commentator on this and every other subject, and should be thought of first among equals. Attorney Melanie Little, new to the game, but, kicking ass in the 6 months or so she's been on YouTube. And John Corcoran, who is good stuff. Now we're going to have some argument about the bullshit. The totality of the circumstances here compels a meaningful and much broader investigation. Does it, though? Does it? To uphold the integrity of the jury process and the right to a fair trial. The evidence of misconduct raised in defense supplement to the motion relating to Juror 1 is not waived and must be addressed in an interview. Furthermore, additional questions listed below in Section B should be put to Juror Number 1 to adequately investigate the allegations of jury misconduct. Finally, Juror Number 1's wife and plaintiff's counsel must also be asked under oath about the note delivered to the jurors and alternate jurors. Oh, that's fun and exciting. That's fun and exciting. Not only do we want to put the wife of Juror Number 1 under oath, but we want to put counsel under oath. Yeah, I don't think counsel's going to be thrilled with that suggestion. Holy shit. Ryan says it was a very petty comment about Megan. Oh, well. This court has declined to interview Juror Number 1 about the evidence and misconduct set forth in defendant's second and third supplement to the post-trial motion for the new trial for juror interview. In the court's view, defendant waived the ability to request inquiry into the facts set forth in the third supplement because the supplement was filed more than 15 days after the verdict. The court found the request into the inquiry regarding the facts in the second supplement waived both because the supplement was filed over 15 days post-verdict and because defendant has a copy of the notes in question before the verdict was entered. Respectfully, this court's ruling on waiver is legally incorrect. No, it's not. It was perfectly fine. Get absolute wrecked. With respect to the court's ruling, the jury note issue is waived because defendant failed to raise it prior to the verdict. It is unreasonable to expect defendant would be able to scrutinize handwriting irregularities in a jury note in the midst of 7 weeks trial. No, it's really not, because you guys had all the lawyers in the world and all the paralegals in the world. No, it's not unreasonable, not for you. And even if it was unreasonable, I'm not sure it matters anyway. Because rules are rules, man. It applies to one person, it applies to a big team too. You know? Furthermore, unlike the extent of Juror 1's pro-plaintiff, anti-defendant bias came to light, the meaning and context of Nazi symbolism used was nearly impossible to appreciate. It wasn't impossible to appreciate for the people on Reddit who you got the suggestion from. Lol. The court itself has not suggested. It noticed the altered first letters of the name when the jury was considered by the court and counsel at bench. If the court had observed these versions of the name, it would have been impossible for this court to rule on November 6th and not seen anything in my mind that remotely give me the conclusion has prejudiced anything in the case. I'm not so sure about that. Also, I don't really think the court will very much appreciate you putting words in the court's mouth. Recovery Addict kicks ass. He's growing and should grow. He's definitely a good channel. We like him very much. And he's been doing great work. We really hope for his growth. Recovery Addict has been awesome. Simply put, there's no evidentiary basis in the record to find defendant made a knowing waiver of its rights to use evidence to challenge a juror who was prejudiced in the case because it did not immediately appreciate the significance of a juror's altered handwriting in one of 100 different questions. In terms of the allegedly untimeliness of the supplement, defendant has complied with the rules which requires the motion for an order permitting an interview be filed within 15 days after rendition of the verdict unless good cause is shown. The motion must identify the juror to be interviewed and the grounds to challenge the party must exist. The motion was filed 13 days after the verdict. I identified the grounds for the predetermined bias in favor. The suspicion juror number one had inappropriate communications with the wife, and juror number one's wife newfound friendship with social media influencer personally connected with plaintiffs. Who cares? Juror number one can be a friend with anyone they want. And, nothing in the rule prevents a party from supplementing a timely motion. I'm not sure that's true. Nothing in the rule prevents a party from supplementing a timely filed motion with additional evidence supporting identified grounds. Yeah, so you can just chain file these things, right? You file it on day 15, and then you can just keep adding things after that date. So you can extend your own limitation period. That doesn't sound right, right? What would be the point of the 15-day clock, right? If you just file the notice on day 15, and you're like, oh, on day 16 I have something more, day 20 I have something more, day 25 I have something more, right? So, yeah, I think it would close out the period. That 15 days is 15 days, man. It's closed, right? Indeed, the Florida Supreme Court has held trial court's rulings that authorized a post-trial investigation of potential jurors, which yielded supplemental information on jury non-disclosure for several months after the original 15-day motion. Well, I don't know the details of that one, right? I don't know the details. So maybe there was some exception or some variant of the rule. I'm not sure that's true here, but whatever. 1,600 of you so far have retweeted the pinned comment. Thank you so much for all of you who participated. It does make a huge difference. Every single one of you who retweets makes a difference. Thank you so much. Also, every single one of you who retweets, the probability someone else will retweet goes up. So there's a nice little chain effect going on there. Similarly, the 4th District Court of Appeals appointed to the common deadlines for filing a motion for a juror interview and filing a motion for a new trial. As proof, the rules contemplate that under normal circumstances, inquiries into jury misconduct will be conducted by the time post-trial motions are determined. Defendant supplements satisfy this contemplated timing. All but one defendant's specific examples of misconduct were raised before the court's order granting the limited interview, and all of the examples were raised, including newly discovered note from juror number's wife to the jurors before the interview itself, which I'm not sure is the relevant time period. Even if it was untimely, there's good cause for delay. Although both supplements contain facts that constitutes good cause, the concealment by the jury of the relevant and material information during the questioning, articulated in the 3rd supplement to the motion, offers particularly pervasive evidence of good cause. Given juror one's direct answer to unambiguous questions and the absence of any reason to suspect deception, defendant has had no reason to delve into juror number one's background. Juror number one's material non-disclosure merits new trial under Florida's 3-part test for considering whether jurors' non-disclosure of information during voir dire warrants a new trial. The relevant law requires that first, the contemplating party must establish the information is relevant and material, which they didn't. They just had hearsay and thoughts and wishes. Second, the juror concealed the information during questioning, which is not at all clear given the phraseology of the question. Last, the failure to disclose the information is not attributable to a complaining party's lack of diligence. Each defendant's supplement field meets the test. The 3rd supplement to juror number one's motion contains significant evidence that juror number one concealed relevant material information during voir dire, and the concealment was not caused by counsel's lack of diligence. That failure to disclose was thus discovered until a month after the verdict cannot justify refusing to consider the effect on the defendant's right to a fair trial. Juror number one affirmatively declared that neither he nor any member of his immediate family had ever been the victim of a crime. In reality, around the same time as the underlying facts in this case, juror number one and his wife reported to the police that they were victims of repeated and violent threats from a family member who they suspected suffered from mental illness. The family member was charged with an offense and ultimately pleaded no contest, receiving the term of probation. Family member does not share juror number one's last name, making discovery of the undisclosed information particularly difficult. I don't know about that. You guys have been investigating the hell out of everyone forever. We all know you have. You have jury consultants. I'm sure they have teased up every detail of every single juror. They know where they eat. They know what they eat, what their favorite food is, what kind of toothbrush they use, what kind of toothbrush. They know what cereal they like. They know everything, man. Don't give me this crap. Lawyers representing clients in litigation are entitled to ask and receive truthful and complete answers to relevant questions which they propose to prospective jurors. They're entitled to evaluate this information, determining whether to seek to excuse prospective jurors on a preemptory challenge for cause. Given the facts of this case, that juror number 1 is the victim of a crime perpetuated by a family member was relevant and material information to which defendant was entitled. Whether concealment was intentional is of no moment. Yes, it really does matter. Incidentally, it really does matter whether it's intentional. Yeah. As the impact remains the same, counsel is prevented from making an informed judgment regarding composition of the jury and utilization of his or her preemptory challenges. The due diligence prong requires a factual determination regarding whether the questions posed to the juror would have reasonably be understood to encompass the enclosed information. Jurors were asked, have you or any member of your immediate family been a victim of a crime? But the person wasn't a member of their immediate family at the time of the crime, so I don't even know how to parse that question. Any reasonable person would understand the question required disclosure of juror number 1's stepsons, violence threats against juror 1 and his wife. Why? They weren't members of the immediate family at the time of the offense. Moreover, the Supreme Court in Roberts made clear that counsel is not required to perform a full public record search on every potential juror. But you did. I know you did. We all know you did. We all know you did a full search. And beyond public records, you did private records. You searched social media. You knew all their accounts. Of course you did. You knew everything about them. Don't front, Johns Hopkins. Don't front. You had the money. You had the resources. Of course you did it. In a particular case, a 10-month post-verdict investigation revealed that 3 jurors failed to disclose prior litigation involvement. Initially, the 3rd District found that counsel had failed to exercise diligence because the time to check jurors' names against the clerk lawsuit index is at the conclusion of jury selection. But the Supreme Court reversed, holding that requiring trial counsel to conduct an investigation of the veneer, which is the fancy word for all the jurors you start with, right? The jury you ultimately wind up with, the 6 people or the 12 people or whatever it is, as the case may be, called the jury panel. The jury panel. And where does a panel come from? It comes from the veneer. Very fancy. Very fancy, the jury veneer. Right? It's one of those aristocratic words. I always want to do like a posh thing, like, oh, really posh woman sort of gesture about when I hear veneer. Have you seen the latest veneer, James? The veneer on this is glorious. That kind of shit. Yeah. Anyways, conducting an investigation of the veneer during a trial is directly contrary to the court's opinion in a different case. Moreover, the court noted statewide information is not immediately available in all courtrooms. But it is now, right? That's the difference, right? This happened, this decision was like 20 years ago. The immediacy of information is much more readily apparent now. You can go to any number of background check websites and check out most people's backgrounds. You know? So the information tends to be readily available. Yeah. More of the court notes statewide information is not immediately available, but it is now. While the ultimate goal is to have all information disclosed, we cannot and must not sacrifice the integrity of the jury process in the name of expediency. But we can't do it because of, just wishes and dreams either. Defendant has not waived the evidence of misconduct. The court should reconsider. Even where plaintiff's counsels concede that juror number 1 simply asked whether he improperly shared information with his wife, he'll simply repeat the denials. So what's the point of asking? An interview that contains only questions about direct communication and shared information will yield no useful information and reveal nothing about whether juror 1 engaged in misconduct. Given the strength of the evidence that juror 1 omitted from multiple pieces of material evidence, harbored a pro-plaintiff bias during the trial. That's not at all what bias means. Bias is not the same thing as judgment. Holy shit. And failed to disclose his wife's extensive contacts with pro-plaintiff social media accounts, which presumes that he knew it. including her presence in the courtroom. Was he supposed to tell somebody about the presence in the courtroom? Was he supposed to tell somebody? And also friendship with plaintiff's advocate, who I'm not sure who that is in this sentence. Is that Jules or juror number one's wife? I'm not sure. Much more is required to determine whether they received a fair trial. In order to adequately investigate it, here's some bullshit questions we want to ask. So these are presumably questions we're going to ask to juror number one about spouse communication during trial, which incidentally, juror number one can, and also his wife, as we've discussed previously, both him and his wife, have the option to exercise privilege in this domain. I don't know what they're going to do in that respect, but, they have the option. And even if I did know, I wouldn't be able to tell you. Please tell us your wife's name. Does she post using the pseudonym Hippo Lover? She sure does. Does she use a hippo as her avatar? Amazingly enough, yes. What devices does she use to access the internet and post online? I don't know. Do you share devices with your spouse? If so, what? Is either your device or hers or a shared device static? That is, a desktop PC monitor, as opposed to a laptop where in your home is it located? Do you and or your wife typically visit social media sites and post in common areas of the home, living room or family room or veranda? And also the word veranda is just super, super fancy, right? Veranda typically is an outside area of a home that is like an extended balcony that's covered. But I suppose any balcony technically qualifies as a veranda. So I guess I have a veranda too. It's a very, very fancy word for like a balcony that basically takes the entire length of the house. It's the sort of that southern architecture thing, right? So you got basically an outside area that typically is the width of the house. So I have a mini veranda. It's just a small one. We also call it a balcony, lol. All right, anyways. But I just think it's a particularly fancy word. Do you guys sit on the veranda? How do you know they have a veranda? Have you been to their house? Have you been checking it out on Google Maps? Doing a little bit of walk-by action? Do you have a private investigator sitting outside their house sometimes? We request that the post attached to juror number one's motion be shown to juror number one. And the following questions posed. Have you seen any attached posts? Which ones? When? During the trial, were you aware your wife was posting comments? Yep. He has to know everything his wife is doing all the time because that's how husbands and wives work. No privacy between husbands and wives, right? They're one and the same person all the time. During the trial, was there any communication between the two of you regarding her online activity, whether verbal or nonverbal? Yes. Sometimes we sent each other smoke signals. Although lately we've been experiencing with semaphore, I'm getting my flag movement down pretty well. You guys want to check it out? Did you later learn that your wife was posting during trial? When? Were you ever present when she was watching live streams or videos, reading information, or posting about the case either before or during the trial? Did you ever discuss your wife's post with her either before, during, or after the trial? Who cares about after? Also, it's privileged. Did you express to her approval or agreement with any of her posts? Privileged. Were you aware at any time that she was paying to accelerate or enhance some of her posts? Did you and your wife discuss the reference case? Privilege. Do you know if she posted reference case before trial? Did you? Were you aware before the trial that she favored plaintiffs? Did you? Well, I already answered that question in the voir dire. Now the spouse's relationship with the plaintiff's team. How did it come to be that your wife was in the courtroom during the trial? Yeah, that's a good question. That's a good question. How did it come to be that your wife was in the courtroom during the trial, right? It's like, yep, I'm responsible for my wife's every movement. I know everywhere she goes all the time, for sure, 100%. And, there's no, I do all the things forever. And, it's just a whole pile of stupid, right? Were you aware of any communications between your wife and Jules? Those women those women with their, conversations, their gossip. Tisk, tisk, tisk. Tisk, tisk, tisk. Were you aware of your wife's presence? Why did you not disclose it? Was I supposed to? I don't remember that instruction. Why didn't you disclose your wife's presence in the courtroom? I don't know. Did she communicate with Jules or Dr. Rickards when she was in the courtroom? How would I know? How would I know? Except that she told me. Privilege, right? It's like, so much of this is just so stupid. Did she communicate with Jules or Dr. Richards when she was in the courtroom? Follow up as needed. Did she communicate with any witnesses for the Kowalski? How would I know this? How would I know any of these things? How would I know any of these things ever at any times? Did she have communication during the trial with any member of the Anderson Glenn law firm? How would he know? How would he know except that his wife told him? How would he know? When did your wife first communicate with Nick Whitney, Greg Anderson, Jennifer Anderson, or any other team? A lot of these answers would be, I don't remember. I'm not sure would be an answer to a lot of these things, I would imagine. When did you become when did you, and why some of them are indented or not, I'm not sure, but who cares? When did you first have contact with Greg Anderson, Nick Whitney, Gene Anderson, or anyone from their law firm outside the courtroom? When did you first have contact with Jules outside the courtroom? When did you first have contact with Dr. Richards outside the courtroom? When did you first have contact with Dr. Patrick outside the courtroom? Do you know Deborah Salisbury? If so, how? Did you have any contact with Deborah Salisbury during the trial, after the trial? Who cares about after the trial? Did your wife have any contact? How would I know this? How would I know any of these things? I don't know. How would I know these things? Defendant has recently learned that in a post-verdict dinner, a note from Juror 1's wife was given to all the attendees, shouting out some good channels, including Uncivil Law, which is the bestest channel. The note provides contact information for Nick Whitney, plaintiff's counsels, Welch, Jack, and Kowalski, and Juror 1's wife. The top of the note reads, we've been given phone numbers from those of you who might wish to contact, and they all said they'd love to hear from you. Next to Nick Whitney's phone number is the following message. Please express our overwhelming gratitude for having delivered justice for Maya, Beta, Jack, and Kyle. All the jurors have fulfilled their solemn duty and forever in their debt. After posting links to various YouTube commentaries that they've followed and comment on the trial, the note includes the following message. As the case is on appeal, be careful what is said to the media. No members of the defense legal team have initiated communication with any jurors, either directly or indirectly. Nor has any member of the defense legal team attempted to deputize an online community. I press serious X's to doubt on that one. The evidence suggests that the same cannot be said for plaintiff's counsel. Note delivers a message directly from plaintiff's counsel to the jurors. Well, I'm not sure if it's directly, incidentally, but, never mind. Expressing gratitude, which is about the most generic statement a lawyer can possibly make. This is not what the rule has in mind. It goes on to say that they'd love to hear from them. Yeah, because someone asked them. Someone asked them, do you want them to contact you? Yeah, that'd be fine by me. That'd be fine by me. And they're just simply relating what the lawyer told them. But cautions that, per Whitney, jurors should be careful what's said in the media. The note further demands inquiry not from just juror 1, number 1, but also the wife, plaintiff's counsel, and Jack, the party. In addition to the questions above, defendant requests the court ask the following questions about the note. Have you ever seen the note? Did your wife deliver this note directly or indirectly to any of your colleagues on the jury, whether jurors or alternates? I'm not sure whether or not I would consider fellow members of the jury to be my colleagues or not, but okay. To whom did she deliver it? Did your wife discuss the content with this note with Nick Whitney? How would I know? Was your wife asked to send the note? By whom? What was the response? Who responded? Now we've got questions for the wife. Hippo lover. Shout out. A veranda can also be a porch. That's also true. A veranda can also be a porch. That's true. But when I think veranda, I typically think not a porch. I think like when I think porch, I normally think of like a ground level structure. But typically when I think veranda, I think like an upper floor structure. But, these delineations. All right. Did you type the attached note or have asked someone to type it for you? Are you capable of typing, woman? Also, how's your sandwich making? Is it any good? Can you please make us a sandwich? Did you deliver the note to any member of the jury on alternate? To whom? Did you deliver it? When? Did anyone ask or suggest, directly or indirectly, you deliver a note to jurors? Who and when? Did you ever speak to Nick Whitney or Grant Egg Anderson or anyone from their office? If so, what were the specifics of the conversation? Oh, man. Were Nick Whitney or Greg Anderson or anyone from their office aware of the note either before or after you delivered it to the jurors? When did they learn the note, and what was their response? How did you obtain Nick Whitney's message to the jury containing the note? When? Now we want questions for the attorneys, who apparently we're going to swear under oath. It's like, well, I'd be half tempted. I think I'd be half tempted to say, I'll agree to be sworn under oath if they agree to be sworn under oath, and they'll have all kinds of exciting and fun questions. You know. Did you know on December 6th that juror number one's wife had been in the courtroom a few days earlier? If so, how did you know? When did you meet juror one's wife for the first time? When? Whom initiated contact? I'm surprised there aren't questions for Jules here, by the way. I'm not sure how Jules lost their interest because there are no questions for Jules. We don't suggest subpoenaing Jules. I'm not sure how that worked, but okay. How did J. Hatch get the note? I mean, it wasn't exactly kept a secret. Who cares? Were you aware of the note written by juror one's wife? When did you learn of it? Do you suggest that juror number one, directly or indirectly, that she deliver a note to the jurors? How did juror one's obtain the message from Nick Whitney? When? When did Nick Whitney say about the juror speaking to the press? When? Did he ask juror number one's wife to deliver the message either directly or indirectly? Questions for the client. Questions for Jack. I have a feeling Jack Kowalski and juror number one would get along pretty well. You know, I have a feeling Jack Kowalski and juror number one would get along pretty well. They seem like they're both, men who are stalwart and resilient and honorable. I think that they could be friends. Maybe they'll become friends. Maybe they'll have picnic dates together. Maybe they'll go for strolls in the park and, have a hot dog and maybe get a balloon as they skip through the park. Maybe do a little hopscotch together. Maybe they could go out for a nice little boat ride on a kayak. That could be fun. And then we could have the whole montage set to my friend and me, my best friend and me together. That kind of thing. And so I think they could be good friends. Has juror number one reached out to Jack and asked him to join him on his veranda? If not, there feels like a missed opportunity here. You should have some lemonade and some sweet tea. It's the Southern way with some ice. It's the Southern way to show hospitality. Little known fact, South Carolina, its official drink is milk, but its official hospitality drink is sweet tea. Yes, South Carolina split the difference. So, for hospitality purposes, sweet tea. For regular everyday purposes, milk, says South Carolina. Not sure about Florida, but I imagine it can't be too far a deviation. All right, questions for Jack. Did you know November 6th, juror number one have been in the courtroom a few days earlier? If so, how did you know about that? I feel like Jack at this point is half tempted to ask you to a knife fight. Just guessing. During the trial, did you communicate with Jules? If so, how did any communications occur? Have you ever been in contact with juror one? If so, when did you make first contact? Defendant realized the scope of this request regarding juror number one is unusual. It's batshit crazy, along with the original motion, but seeing as the judge gives Johns Hopkins whatever they want and says, "Can I have another, sir?" Just bends over and says, "Can I have another, sir?" Who knows? But this case is extraordinary in many ways, including the unprecedented traditional and social media it's received. Again, it's not that unprecedented, really, but okay. The detailed evidence of juror misconduct that's been exposed requires an inquiry sufficient to determine or defendant received a fair trial, or the integrity of the system was compromised. The limited scope of the inquiry contemplated is inadequate. The interview must add additional questions as set forth, and then we want to have the interview. Now, I have taken the position before, and I don't mind repeating the position that juror number 1 should invoke privilege. And it's largely because of this. Like, I could see this coming, and anyone who is paying attention can see this coming, right? It's like it's never enough with Johns Hopkins. It's never enough, right? So Johns Hopkins is going to get whatever they want. And even if they literally got everything here, they still wouldn't think it's enough. That's my thing, right? It's like, it's not about whether juror number 1 has something to hide at this point or not. To my mind, like, that's not the principal consideration, right? I'm beyond whether juror number 1 has something to hide or not. I'm just like, I don't want to play anymore. I don't want to play anymore. I'm taking my marbles and going home. You know, I don't want to play anymore. And that's how I feel about it, right? And I don't know whether juror number 1 and his wife will invoke privilege. And I, incidentally, ultimately don't care, right? It's up to them. It's totally up to them. It's always been up to them. I just am happy that they have a lawyer and are getting competent legal advice. And whichever way they decide to go on this thing, I totally respect their decision. You know, I'm just happy that they have a lawyer that's representing them and giving them independent legal advice. That makes me happy inside, right? Beyond that, I don't really care. I was happy to do it myself, but I'm glad they have somebody. You know, so no hurt feelings on my part. You know, no hurt feelings is fine. But speaking strictly for myself, and absolutely no way speaking for them, even if I knew, right? I would invoke privilege because I just don't want to play anymore, right? Because you saw every time you give them a cookie, this is what Rob says, right? Every time you give them a cookie, they want another cookie. It never stops. And so, sure, invoking privilege is going to make them bitch all over the page and ask for adverse inferences and all the rest of it, right? So Rob isn't wrong about that. Rob is not wrong when he says if juror number 1 and his wife invoke privilege, they'll ask for adverse inferences and all the rest and bitch all over the page. They're not wrong. The problem is, if juror number 1 does everything they want, they're still going to bitch all over the page. They're already bitching all over the page. They're bitching all over the page now about how they didn't get enough. And even if they got all this, they'd still be bitching, right? And we've already heard them bitch because they've already said, well, we want access to the devices. We want discovery of the devices. You know, we want to see their phones. We want to see their emails. We want a preservation letter so we can get access to the things. So that's the thing. Like, it never stops. It never stops. So that's where I sort of have a problem with it. So that's sort of like, well, no one else is going to tell them to stop. No one else is going to tell them to stop, so I'll tell them to stop. You know, we're invoking privilege. Screw you. So mostly it's just a screw you at this point. I don't want to play anymore. But again, it's totally their decision, and I respect them either way they want to go. All right, I've got about 12 minutes before Recovery Addict starts again, and I want to get you back on time because he was kind enough to send me the redirect in the first place. Just a friendly reminder, by the way, once again, I know I mentioned it a couple times, but I really do need your help. I really need your help, please. This is one of those occasions when, you know, your help will really make a difference. So you can help me not by giving me any money. You don't even need to give me money today. You can just help me by please retweeting the pinned comment, along with appropriate, you know, customization. You know, add a few words of your own, and remember to be nice about it. But you know, the retweeting helps a lot. So yeah. But I've got 12 minutes left before he starts, and I want to redirect you that way so you don't miss any of it, out of respect to him. I've got 11 minutes left. So the only thing I want to cover left is a little bit of plaintiff's notice of filing response. And the only thing I want to cover in this response is Exhibit A. Because we have an affidavit from the Deborah Salisbury that we've heard so much about, right? We've heard so much from Deborah Salisbury about this thing and who Deborah Salisbury is and their interactions with juror number 1 and their wife and all the rest of it. Who is Deborah Salisbury, right? So Deborah Salisbury comes to the fray and says, okay, here's who I am. First, she writes, I've been duly licensed to practice in Florida since 1993. She's been around for a hot minute. She has been continuously a member of the bar in good standing for more than 30 years, despite practicing in the difficult area of family law. And then she has this sentence which is like basically the FU, right? This is basically the FU sentence. I stand on my reputation as an officer to the court as to these circumstances. That is lawyer speak for go fuck yourself. Right? That is lawyer speak for go fuck yourself. Because that is just throwing your balls right down on the table and be like, okay, I am standing on my reputation. I am telling you as an officer of the court, this is true and you can rely on it. Right? This is putting your balls on the table. Because you're like, I am telling you, court, this is true. This is the kind of thing where if it's not true, the bar may very well whack off your balls, right? So this is putting your balls right on the table and saying, I'm all in. You know, come for me, bro. Come for me. You know? Anyways, I have been board certified in juvenile dependency law since 2018. As the court may recall, I represent Jack Kowalski because, you know, the judge himself was there, lol. And at times, the decedent, Beata Kowalski, in the underlying shelter and dependency action brought by Department of Children. I have been disposed of in the present case. So I represent them in the dependency action, but not much more. Okay. On Friday, December 15th, I was present in the gallery of the courtroom where this honorable court for oral arguments on issues involving claims of misconduct and his wife. At that time, the defense attorney, Shapiro, represented to this court the undersigned attorney, that would be me, not me personally, but, you know, the lawyer signing this. The undersigned attorney had represented Juror 1's wife in his prior divorce case. As an officer of this court, second time, I'm going to put my balls on the table, I bring this misrepresentation of the record to the court's attention. I herein state to the fullest extent of my knowledge, Juror 1 and or his wife, prior to being in the courtroom and learning what I take to be an attack by defense on my professional integrity, personally as attorney based on allegations. It's like, yeah, I'm taking this personally. You've come after me. You've come after my professional reputation. Go F yourself. Hey, MLS and their viewers are dropping by. Hey, MLS viewers, as long as you're here with the raid, I'll remind you guys, MLS viewers that are coming in, to please retweet the pinned comment. I really do need your help. Thank you. Thank you for dropping by. During 2007, I was court-appointed counsel to represent another individual involved in the case, the family case. Given the confidentiality rules, I'm prohibited from identifying my client, who was almost certainly a minor child. Right? Is almost certainly a minor child because we're talking about a divorce case. Right? So who needs an attorney besides the husband and wife? Who else would have a legally recognizable interest in the outcome of a divorce? It's presumably the child, right? I mean, who else could it be? But, you know, we can't say that publicly, but that's almost certainly what the case is, right? So I represent the child who naturally has a lawyer of their own, is naturally adverse to both parties because they might want things that are different from both parties. So they are adverse to both parties, right? So everyone's adverse to everyone, right? All right. Per above, Yolanda Phelps, the wife, attended a brief hearing, and though I may have seen her, she's represented by other counsel and I no way represented her. In this context, Ms. Phelps, as petitioner for the divorce, was more or less in opposition to my role because I represent the child, although I can't say that out loud, right? So my client's interests, like the husband's interests, are adverse to the wife, right? So my client's interests, presumably the child, are potentially adverse to them both because I might want different things from both of them. So yes, she was in opposition to me because I was representing a party with potentially conflicting interests. To represent in any fashion as counsel to Ms. Phelps or her current husband, Paul, now unfortunately for him being reduced to juror number 1, although I'm not sure necessarily that's an insult at this point. I put that on my damn license plate, lol. Is a misrepresentation. While I was an attorney of record in Ms. Phelps' divorce case, is an objective fact, easily confirmed by the docket, demonstrating I was never counseled anyone involved in the present case. Yeah, so the docket says who were the parties representing them, and I'm not that. So, yeah. I respectfully request this court acknowledge, and any issues ordered out of the circumstance, I've completed my duties. by notifying the court of this intentional misrepresentation. They're lying about me, Your Honor. I'd really appreciate it if you'd make that a record, because they've been slamming my reputation. I'd really appreciate it if you feed their own balls to them because they told you lies. And now here I am putting my balls on the table, and I prefer that you feed theirs to them than mine because they're lying to you. But Johns Hopkins lawyers tell a lie or something that's not completely true. I mean, that sounds so unlike Johns Hopkins lawyers. I mean, we've never seen anything like that ever before where Johns Hopkins lawyers might be misleading the court or deceiving the court or lying to the court. No track record of any of that. Okay. If any effort to review the docket from the divorce case were undertaken, let alone contacting me, they didn't even have the basic courtesy to contact me. What losers. I would hope counsel would do, if nothing more than as common courtesy, they could easily confirm the undersigned attorney was never counsel to, nor an attorney of record, nor in any way the legal representative of juror number one's wife, previously known as Yolanda Phelps, in the divorce case. You could have checked. You could have called me. You could have asked. You didn't. You're a bunch of assholes. Any review of the record or even the trial docket will show that neither party was represented by counsel. This fact could not be any clearer. The assigned counsel has never represented juror number one's wife or juror number one in any capacity whatsoever at any time. Based on my best memory, undersigned counsel has never even met juror number one. Furthermore, I've never met juror number one's wife other than as indicated below. I don't know who these people are. Signed, Desborough Salisbury, Esquire, dropping her big-ass lady balls right on the table because she has big-ass lady balls, and I love it. I am here for it. I love you, Deborah. I love you. I would have personally tolerated many levels of spicier than this and been quite happy with it, although I do somewhat appreciate your professional restraint. I'm not sure I would be this professionally restrained. I'm not sure which of us has it better, but, you're probably better to be this professionally restrained. I'm not sure I'm capable of this level of restraint when I feel this called out, but, yeah. The last line, further affiant saith not, is a very typical line in a affidavit, but I do like that it has a particular mic drop quality to this. It's a very typical line to say in an affidavit, but I do like that it has a particular mic drop moment. Further affiant saith not. So yeah. So she has lady balls. She has lady balls, and I'm here for it. And I appreciate her restraint, even though I'm not capable of it. I appreciate that she wrote a very lawyerly version of go fuck yourself. So yeah, that I appreciate. All right, we got about 2 minutes left before Recovery Addict starts, and I don't want you to miss much. So I'm gonna go snipe his stream, so you guys don't miss anything. And then as soon as he starts, I'll send you over that way. So I wanted to get it in within the hour and a half. And I managed to do it. I managed to do it in an hour 28. Look how good I am. So my last plea, please remember to retweet the pinned comment. Tell your friends. Give the thing a heart. That's good. Why don't you give the thing a heart? Maybe give, you can just always give, also, you can, in addition to giving a retweet, how about this? You can, in addition to giving a retweet, how about you just also leave a comment? You leave a reply. That'd be good. You can do both. There you go. Give a little reply, and do at YouTube, at YouTube creators, at Team YouTube. Put the same ats and give a little reply. Hashtag free Steamboat Willie, if you like. Hashtag free the mouse. I don't know. Hashtag Uncivil Law is the greatest lawyer ever. I don't know. Make up your own thing. But give it a little comment. Well, there's only 20 comments to the thread. So, now would be an opportunity to give a little comment. So hit the link and give a little comment. Just a couple words. Doesn't have to be long. It's just a little thing. It'll help. What's the tweet about? YouTube is trying to take me down, man. YouTube is trying to take me down. YouTube gave me a community guidelines warning for repeatedly violating copyright law during a YouTube stream. Right? So they struck my stream 3 times. And then the 3rd time they deleted the stream altogether, right? For repeated copyright violation. And because it's a repeated violation, apparently that becomes a community guidelines strike, not just a copyright strike. So it becomes a community guideline strike, which is a pain in the ass. And the copyrighted material in question is not copyrighted. It's Steamboat Willie. It went out of copyright yesterday. I was doing a stream about it and doing a legal analysis about it yesterday. And they kept taking down my stream. Oh, it looks like Recovery Addict is getting started. So it's time for me to wrap up the stream because we love Recovery Addict. So I'm going to send you over that way because it looks like his stream is live and I don't want you to miss anything. So yeah, YouTube is after me for repeated violations of streaming copyrighted content that is not copyrighted. It's in the public domain. It's 95 years old. It expired. It is not copyrighted. It is not copyrighted. It was December 31st. It wasn't yesterday. So their strike is invalid. Also, Twitch has taken my stream. There's the words, man. It's time to send you that way. Recovery Addict's theme music is starting. All right, guys, I'm going to end the stream. We're sending you over to Recovery Addict so you guys won't miss anything. I love you all. Until later, my friends, I hope all is well. Cheers, my friends. And for now, goodbye.